Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review.
Hi everyone, my name is Elizabeth Montano, better known as Liz, and I am not Kevin A. Gregg, but I am your host this week. If you're a longtime fan of the pod, then hello again. I'm sure you've been wondering where I've been. If you're new to the pod, then hello for the first time. I am not the regular host of the pod, but he'll be back soon. For now, you're all stuck with me. This week, something miraculous happened that has never happened ever in the few times I've done the pod. Only one case was published. I think the circuits felt bad for Kevin for giving him 20 cases in August to cover in just 2.5 weeks, so they wanted to go easy on him this week. Well, he's not here, but I'll take the gift. And for the cherries on top, it's a non-citizen-friendly decision on asylum out of the Fifth Circuit. Wild. So, today's episode is going to be short and sweet. Here we go.
Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes.
Our first and only case is Aben v. Garland, published by the Fifth Circuit on August 20th, 2024. This is a case about the substantial evidence standard in the context of asylum, withholding of removal, and CAT claims. Mr. Aben is a nurse from Cameroon who fled the country and arrived in the United States in 2019. Upon arrival, he applied for asylum, withholding of removal, and CAT protection. To fully understand Mr. Aben's claim, please enjoy a brief history lesson. In the early 20th century, France and Britain divided the Cameroonian territory after taking it from Germany. In 1960, the French-speaking section, or the Francophones, gained independence as Cameroon, and the English-speaking section, the Anglophones, joined a year later. The Francophones dominate the government, and the Anglophones claim they are marginalized. Protests by Anglophones in 2016 and 2017 triggered a violent crackdown from the Francophone government, leading some Anglophones, who the Fifth Circuit referred to as separatists, to launch armed attacks in response. Now that we're all caught up on history, where does Mr. Aben fit in? Well, he is an Anglophone and was a nurse in Cameroon. And while he testified that he himself had never taken part in any political demonstrations, he did treat Anglophone separatists who were wounded in conflicts. This, in turn, prompted Francophone military to accuse Mr. Aben and other hospital staff of treating, quote, separatist fighters, end quote, which led to harassment and threats, beatings, and arson of the hospital. Eventually, Mr. Aben decided to flee. On his journey, however, he was encountered several times by the military, and each time suffered various forms of harassment, beatings, threats, and other abusive treatment at the hands of the military. In short, he was arrested and detained 3 times, held in unlawful captivity for a total of 6 days, slapped, kicked, and knocked in the head, beaten with a belt and a stick, suffered several lacerations, blisters, sores, and bruises, threatened with death while held at gunpoint, witnessed other Anglophone detainees be taken out of holding never to return, and was told he would be killed if he did not run fast enough to escape. So, once he finally got to the United States, Mr. Aben applied for asylum, withholding of removal, and protection under the Convention Against Torture. According to Mr. Aben, he suffered past persecution and had a well-founded fear of future persecution based on his imputed political opinion and membership in several particular social groups. But the imputed political opinion claim is the real star of the show here. The immigration judge denied all 3 claims, and the BIA affirmed. We'll discuss the highlights in detail, but spoiler alert, the Fifth Circuit denied the petition for review as to Mr. Aben's CAT claim, but granted the petition for review as to his asylum and withholding claims, all because of a little thing called the substantial evidence standard. Let's get into it. As I'm sure you all know by now, findings of fact are reviewed under the substantial evidence standard, which means that a court cannot reverse a factual finding unless the evidence not only supports reversal, but compels it. In other words, the evidence must be, quote, so compelling that no reasonable fact finder could reach a contrary conclusion, end quote. While this is a deferential standard, it doesn't give the BIA carte blanche to disregard evidence it doesn't like or want to review. Indeed, quote, the BIA's complete failure to address uncontroverted evidence does not meet this standard, end quote, and a court cannot affirm a decision that, quote, fails to address key evidence, end quote. According to the Fifth Circuit, the BIA did just that several times when deciding Mr. Aben's asylum claim. First, the Fifth Circuit held that the BIA failed to consider uncontroverted key evidence when determining that Mr. Aben had failed to prove past persecution, specifically the credible death threats that Mr. Aben received. According to Mr. Aben, various soldiers he encountered in his flight told him that they would kill him and all the other, quote, Anglo fools one by one, end quote, and that they would not bother to take his ID because he would be killed shortly. Mr. Aben also witnessed several other Anglophone detainees be escorted out of detention, never to be seen again, and he testified that he believed that they were murdered. But the BIA didn't consider this key evidence. And while the Fifth Circuit acknowledged that death threats alone are not necessarily persecution, the court stated that when, quote, credible death threats are accompanied by beatings, they cannot be said to be inconsequential, end quote, and that, at the very least, the BIA must address that evidence. Thus, the Fifth Circuit vacated the BIA's decision as to past persecution. Second, the Fifth Circuit held that the BIA also failed to consider uncontroverted key evidence when concluding that Mr. Aben had failed to prove a nexus between his harms and the protected ground. As a reminder, Mr. Aben argued that he was persecuted on account of a political opinion the persecutors imputed onto him, not one he personally held. That he was an Anglophone separatist, or at least actively fighting against the Francophone government due to separatist allegiance, because he was a nurse who had treated actual known Anglophone separatists. The BIA didn't agree and stated that the actions taken against Mr. Aben were not politically motivated, but instead were due only to his occupation as a nurse. But the Fifth Circuit highlighted that there was no evidence to suggest that all nurses were being targeted regardless of political opinion or who they treated. But there was substantial evidence that the government imputed a political opinion of separatist allegiance or Francophone opposition to Mr. Aben, none of which the BIA considered. This included numerous pieces of testimony from Mr. Aben that the police mentioned his Anglo heritage on almost every occasion that they stopped him, and that soldiers claimed several times that Mr. Aben was, quote, fighting them, end quote. Because of this, the Fifth Circuit agreed with Mr. Aben that while his position as a nurse played a role in his persecution, it was not the only reason for his persecution. Remember, the protected ground need not be the sole reason for the persecution. It need only be one central reason. And here, the Fifth Circuit believed that the political opinion imputed onto Mr. Aben likely was one central reason that led to his persecution. As a result, the Fifth Circuit vacated the BIA's determination regarding nexus. Third, the Fifth Circuit held that the BIA erred in finding that Mr. Aben had failed to present evidence to corroborate his claims, because the BIA again, quote, failed to address obvious pieces of evidence, end quote. The BIA and the immigration judge faulted Mr. Aben for not documenting his injuries with pictures or medical records. But Mr. Aben testified that the authorities seized his cell phone, that he was afraid to use a different cell phone because of what the authorities would do if they found it or any form of documentation, and that he avoided hospitals because of fear. According to the Fifth Circuit, this meant that the two means of documenting his injuries that the immigration judge faulted Mr. Aben for not using were actually unavailable to him based on the record. And neither the immigration judge nor the BIA addressed how Mr. Aben could have, quote, reasonably obtained corroborating evidence in light of this, end quote. In fact, Mr. Aben did submit some evidence to corroborate his claims, including affidavits from friends in Cameroon and Nigeria. But the BIA failed to address this evidence, and, as a result, the Fifth Circuit vacated the BIA's finding that Mr. Aben failed to present evidence to corroborate his claims. Fourth, and finally, the Fifth Circuit held that the BIA erred by failing to consider key evidence as to Mr. Aben's claim that he had a well-founded fear of future persecution. Specifically, the BIA held that Mr. Aben's claim, quote, was not objectively reasonable in light of the significant change in country conditions, end quote. This country conditions evidence detailed, quote, peace talks between the separatists and Francophone leaders, end quote, and reports of asylees returning to Anglophone Cameroon and prisoners being released. However, the Fifth Circuit pointed out that the BIA did not consider evidence in the record that contradicted this so-called significant change in country conditions, including statements made in the government's own country conditions materials. In fact, while those materials may have mentioned peace talks and positive progress, they also stated that, quote, atrocities have resumed strongly, end quote, in Anglophone Cameroon. Because of this, the Fifth Circuit vacated the BIA's decision as to this issue and remanded to give the BIA an opportunity to address not only the most recent country conditions evidence, but also any effect that DHS's TPS designation for Cameroon may have. In the end, the Fifth Circuit vacated the BIA's decision on Mr. Aben's asylum claim because it believed the BIA had failed to meet the substantial evidence standard. And because the BIA denied Mr. Aben's withholding of removal claim solely because it found him ineligible for asylum, the Fifth Circuit also vacated that decision as well. So, thanks to Dr. Alicia Trish of Trish Immigration Appeals, as well as attorneys Philip Hunter and Paul Scott of the Scott Law Firm in Baton Rouge, Mr. Aben will get another day in court. Congratulations! And that was our one and only case this week, Aben v. Garland.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.